All right, there we go. Sorry about that, everybody. Hello, welcome in. Hello, welcome everybody. Hello. Sorry about that. I needed to put it on my sub chat. So, hello, welcome in everybody. Happy Sunday. Happy Sunday evening. I do have us set to a sub chat, which I do on Sundays only. Just to give my moderators a break. So I have the chat just set to subscribers, but everyone is welcome to come and hang out and listen. So hello, everyone. Hello, hi, Kaya. Good to see you. Hi, Mary. Hello, welcome in. Good to see everybody. So here we go. Let me make sure I had there we go. Trying to get everything lined up. Hello. Yes. Glad to be back. For sure. I had to make sure I rested up plenty to make sure I could come back tonight. I think we've missed the last couple sub chat Sundays, so I've been really bummed out about that. So I'm glad I was able to come back and do our sub chat Sunday again. So for everyone just joining, I do have my chat set to subscribers only, but everyone is welcome to come and hang out. I do this once a week for my subscribers and to give my moderators a break. So welcome in, everybody. Hello. Hi, Willie B. Hi, welcome. Hello, Desert Skies. I hope everyone has been having a lovely Sunday. I was on earlier this morning to talk about the New York fraud case, and so we had some charts, had some evidence we could go through that is posted on my tube of you now for anyone who is interested. But that was this morning pretty early, 9 o'clock. And then I was able to come back on again tonight. I'm doing just fine today. I'm doing just fine. Hello, Shell. Hello, Estelle. Hello. Yes, glad things are working out. Absolutely. Doing much better. We just never know. Every day is different, right? So every day is a little bit different. But oh my gosh, everybody, do I have a great document for you tonight. Oh my goodness. I have a very interesting opinion here out of the District of Columbia. And we have an attorney here that had some pretty bad behavior, and so she has been removed from a civil case. So this memo, or this memorandum opinion, 62 pages. So I will make it through at least a big half of the chunk here. But wow, this judge has got some pretty spicy language here for this attorney. No, not yet, Lisa. Not that I've seen. His brief is due on Tuesday for Florida, and of course he could file anytime now, but I have not seen a filing yet before I came on tonight. So, hello. Yes, I am. I am feeling better. Thank you so much. Yes. Hello, Tay. Good to see you. So tonight, everyone, I will be taking you through this decision. Again, this is out of the District of Columbia, and this was filed August 13th. This is a very interesting order here where we have an attorney removed from a case based off of her bad behavior, and this is part of a sanctioning process. So this has to do with the U.S. Dominion voting systems lawsuit that was involved, and this attorney was way out of line, did some very inappropriate conduct. The judge has called her out on it, and so this is the order, and it's 62 pages of calling her out. So very interesting case, and I will be taking you through that tonight. Yeah, he's taking his time, and I think it's just because he wants to make sure that everyone's kind of on the same page, because we do have a filing in New York, which is the first to kind of talk a little bit about this immunity situation, but this will be the first filing in the federal court, and so I think he's trying to be extra careful for sure. Hello, Bruce Wayne Mother. Good to see you. Welcome, everybody. Yeah, I think he's just being a little extra careful in this particular situation. Can't blame him, and he's got plenty of time too. So his filing is due this week also. Sorry, everybody, got my cases mixed up. His DC filing is due also this week. So we have a Florida filing due by Jack and the DC filing due this week, everyone. So he's got 2 filings due this week. So I apologize if I get Florida and DC mixed up a little bit, but this week we should have 2 pretty major filings coming in. So it will be interesting to see what he does with both of those. So welcome in, welcome in. I do have my chat set to subscribers only. Everyone, of course, is welcome to come and hang out. So tonight, everyone, I thought, since we're in a sub chat here, let's go ahead and start working our way through this Dominion decision that came down out of the District of Columbia. So this is a pretty major decision here. Yes, he still has Blanche. It's so easy to get the case mixed up. There's so many. There really are. There really are. Relaxing evening. Well, I think so. I am feeling better, Kate. Thank you so much for asking. Yes, I am doing much better today. So thank goodness. But yes, so this is, again, it's a 62-page opinion, everyone. I will definitely make it through at least the first half, but I may need to do the second half tomorrow night. We'll have to see how things go, but this opinion, everyone, is just, it just blows your hair back. It's just scathing when it comes to improper attorney behavior here. So I will go ahead and get a sticky note put together for tonight. Hello, Andy. You made it. Yay. Welcome. Good to see you. So this is the, let's see, August 13th. Let's see, what do we want to call this? The attorney removed from case. Attorney removed from lawsuit. And this was, let me just make sure I have the correct attorney here. We've got a judge here. And let me make sure I spell the name correctly. Oop, I already messed up, everybody. Here we go. Yeah. There we go. Magistrate judge here. So this is the Dominion. Yes, this is one of many of the Dominion situations still ongoing. So this is Dominion versus Bayern. So that's our case. Hello, welcome. Yes, welcome back, everybody. Glad to be back. Posting your lives. Yes, I am. I'm trying to post them either. It's interesting because sometimes my lives will not post on TikTok. They just say that it's a violation. And even though it's my own live that TikTok has recorded, they're like, well, this is a violation. We won't post it. I'm like, oh, okay. So if it's under an hour, I can post it here on TikTok. If it's over, or if they give me kind of any rubbish about it, then I just put it over on my Tube of You channel, everyone. So I'm trying to post these as quickly as I can right after I finish doing them. So I don't know what's been going on here on the talk recently, but there have definitely been some little interesting bits going on here. So this again is a case where we have a lawyer behaving really badly, and a judge is going to be calling them out on it. So let me go ahead and get started here, everybody. This is a very interesting case. So we have this order here. This is the action number. We've got U.S. Dominion, so Dominion Voting Services and Dominion Voting Systems Corporation as the plaintiffs versus Patrick Byrne. We'll just call him Byrne, all right, as the defendant. And this is the opinion given here by the judge where he has pulled one of the attorneys off the case for bad behavior. So this is a pretty significant decision here. So let's go ahead and dive right in, everybody. Hawk's having trouble too. I think there's something hinky going on. Hinky, everybody. But we'll just keep on trucking here. Byrne. All right, let's call it Byrne, Mary. Let's do that. I always want to give it a little extra something, but for some reason I never feel like that's correct. So here we go, memorandum opinion. This case arises out of the 2020 U.S. election. Plaintiffs, U.S. Dominion Voting System Corporation, sued defendant Patrick Byrne for defamation related to allegedly false statements Byrne made about Dominion's role in that election. Again, this decision was just on August 13th. Among the statements at issue are those in which Byrne claimed that Dominion ran the 2020 election. Dominion technology was developed by Hugo Chavez in Venezuela, and that Dominion hired a truck to shred 3,000 pounds of ballots. Before I get too much further, everyone, we do have a footnote number 1 up here, so I will bump down. The other cases that are consolidated or coordinated for discovery here are Dominion versus Herring Networks, Dominion versus My Pillow Incorporated, Dominion versus Powell, that would be Sidney Powell, and Dominion versus Giuliani. The Giuliani cases stayed pending bankruptcy proceedings, which, as I have done a live on that, his bankruptcy has been dismissed. For all citations not otherwise specified, the court cites to docket entries in case number set out here in the page numbers in the ECF headers. So anything highlighted in yellow is just a reference back to the record, everyone. So this is a public record. Really made a post about TikTok preventing something. Yeah, very interesting. It's an interesting time. So Dominion asserts that these statements are false and not only harmed its reputation and business, but also resulted in serious threats to its employees, their families, and election workers. This litigation, let me make sure I'm in frame, everyone. So here we go. This litigation has been ongoing for nearly 3 years and is currently in discovery. This dispute centers on that discovery process. Specifically repeated instances of non-compliance with the court's orders governing the disclosure and use of discovery material. So this is where this attorney is going to get into some serious trouble, everyone. From June of 2023 until March of 2024, all counsel and parties in the case, including Byrne, seemingly abided by the amended protective order governing discovery. Before even her first appearance in this case on March 12th, however, Byrne's new counsel, Stephanie Lambert, so we'll refer to her as Lambert, began openly violating the orders, including by disseminating protected discovery material. So this attorney was putting out protected information that had no business being out in the public here. Due to Lambert's actions, thousands of documents, which all parties, including Byrne himself, had agreed to keep confidential, have now been shared widely in the public domain. Lambert and Byrne continue to evade the protective order and this court's March 19th, 2024 order that prohibits further dissemination until resolution of this motion. Before the court is Dominion's emergency motion for protective relief and to disqualify counsel. Although Byrne has violated the protective order as set forth below, the full scope of Byrne's actions is not yet known. And what, if any, sanction Dominion might seek against him is not before the court at this time. So we have footnote number 2 here. Dominion has reserved its right to seek additional sanctions against Byrne and requested additional discovery into his conduct, including what led to the ultimate disclosures. So there we go. The only question currently before the court are whether Lambert violated court orders and rules, and if so, whether she should be disqualified from this case. The remedy Dominion seeks, Lambert's disqualification from serving as Byrne's counsel in this case, is extraordinary and rarely granted outside of cases involving conflicts of interest. Nevertheless, the record clearly shows that Lambert deliberately violated multiple court rules and orders and continues to do so, despite having had ample warning of the consequences and assuring the court she would comply. Lambert's repeated misconduct raises the serious concern that she became involved in this litigation for the sheer purpose of gaining access to and publicly sharing Dominion's protected discovery. Because Lambert's truly egregious misconduct has already and will undoubtedly continue to infect future proceedings, this is the rare case in which disqualification is warranted. So that's huge. Oh, thanks, Andy. That's a huge moment in time where an attorney is being disqualified from a case. So Dominion's motion is granted. Here's our background. The relevant facts are largely undisputed. The protective order. The court initially entered the protective order in 3 related cases, which are now coordinated or consolidated for discovery, on December 6th of 2022. On June 8th of 2023, Dominion and Byrne jointly moved the court to enter the December 2022 protective order in this case. Per the stipulation, Byrne expressly agreed. The order governs the handling of discovery material within the consolidated cases and allows the parties to the order to share discovery materials between those 3 actions, but prohibits persons or entities receiving discovery material produced in the consolidated cases from using those discovery materials outside of those 3 cases, except as specifically provided by the order. So that was stipulated to by all the parties. Dominion and Byrne requested that the protective order be entered in this case to facilitate voluntary discovery coordination. The court granted the parties' joint motion and entered the protective order in this case on June 16th of 2023. The protective order states, before I dive in there, let's back up. We've got a footnote here, number 3, which states Dominion attached ECF, so that's an electronic filing of number 46, to the motion at issue because it was the operative protective order at the time. On March 21st of 2024, after Dominion filed its motion, the court entered an amended protective order to which all parties agreed. The protective order at number 79 is now operative, the operative protective order, but does not alter the relevant provisions of the initial protective order that has governed party conduct in this case since June 16th of 2023. To avoid confusion, the court will use the ECF citation and page number for the ECF number 75-7 when citing to the protective order going forward. So there's a little housekeeping moment. Protective order states, T. Oh, are we ready for T already? Hold on, Seuss. Actually, all right. All right, there we go. Staying hydrated. How many more attorneys? It's a lot, everybody. All right, the protective order states, any discovery material produced in the litigation will be used except by the producing party solely for the purposes of this litigation, and no receiving party will provide discovery material to any person or entity, including for any other litigation, or make any discovery material public except as permitted by this order and in this litigation. The protective order defines discovery material as documents, testimony in any form, whether by affidavit, declaration, or deposition, exhibits, transcripts, written discovery, requests, interrogatory responses, responses to the request for admission, responses to requests for documents, and any other information or material produced, given, or exchanged, including any information contained therein or derived therefrom, by or among any party or non-party providing discovery material in the litigation to the party receiving the discovery material. All right, so we get excited. Yes, we've got some iced tea going on tonight, everyone. It's super hot in my neighborhood today, so within the broad prohibition against using any discovery material outside of the related litigation, the protective order contains additional protections and procedures for the use of confidential and attorney's eyes-only material. So eyes-only material, everyone, or AEO. The protective order also sets forth procedures for how a party can seek to challenge designation or disclose discovery. So if they would like to disclose it, there is a process they can go through, notwithstanding the order. Paragraph 16 sets forth procedures for a party to object to the initial designation of discovery materials as protected. Specifically, it permits a party to object to the designation of discovery material as confidential or eyes only by sending written notice to and meeting and conferring with designating party. If this process does not resolve the issue, the objecting party may file a motion with the court to strike the designation within 21 days of the meet and confer. Importantly, while the dispute's pending, the discovery materials will be treated as confidential or eyes only pursuant to the order. So he's going through the process of how you can pull that discovery off of the eyes only, but there's a procedure here. Paragraph 15 allows a party to object to the continued restriction on public access to confidential eyes only discovery material. Any party who objects to the continued restriction on public access to any confidential or attorney's eyes only filing or any portion thereof will give written notice of the objection to the party that designated the discovery material as confidential or attorney's eyes only. To the extent the designating party seeks to continue the restriction on public access to the confidential or attorney's eyes only filing or any portion thereof, the designating party will file an application with the court within 7 days for a judicial determination as to whether good cause exists for continued restricted access to the confidential filing or any portion thereof. Paragraph 8 and 9 permit confidential and eyes-only material to be disclosed to certain people, some of whom must sign an undertaking to gain access. The party showing, providing, or disclosing confidential or eyes-only discovery material to any person required to execute an undertaking will be responsible for obtaining such signed undertaking. Additionally, paragraph 26 requires that if a person in possession of confidential or eyes-only discovery materials that they did not produce receive a subpoena for those materials, they must, 1, give notice of the request of the designating party within 3 business days or 24 hours if the subpoena deadline is sooner, and 2, object to the production of the confidential or eyes-only discovery material on the grounds of the existence of this order. If the designating party opposes enforcement of the demand, the burden of opposing the demand falls to them. This provision does not require the person or party who's subpoenaed to appeal an order enforcing the demand or to otherwise seek relief from compliance. If a party discloses discovery in violation of the protective order, the breaching party must immediately inform the designating and producing party and provide an accounting of the disclosure. Additionally, the order allows a non-breaching party to seek sanctions against the breaching party. So we definitely are in the land of sanctions here. If a party violates this order by releasing, leaking, or otherwise disclosing confidential or eyes-only discovery material to persons or entities not entitled to such discovery material under this order, the court will have authority to impose sanctions under Rule 37 sub B sub 2 sub A 1 through 6. And then we've got footnote number 4 here. As the plain language of the Federal Rule of Civil Procedure permits sanctions against parties for discovery-related misconduct or dispute, Dominion relies on this motion, on the court's inherent authority to regulate counsel before it. So Dominion is saying, we want sanctions, but whatever you think those sanctions should be is up to you. According to Dominion, the parties negotiated the protective order given the national security concerns regarding voting machines information and the personal security concerns for Dominion employees, many of whom have been subject of threats in the past. This concern is one of the reasons why the protective order applies to all discovery produced in this litigation, regardless of whether it's stamped confidential or eyes only. Other justifications for the parties' protective order included their belief that certain information they have produced or will produce may contain information that's proprietary, commercially sensitive, or non-public. Significantly, after stipulating to it, Byrne never objected to the protective order. He never asked the court to amend or lift the protective order until after he and Lambert began disclosing Dominion's litigation documents. Then we have footnote number 5 here. Byrne filed a motion to lift the protective order on April 18th of 2024. In addition to the protective order governing all-party discovery, Dominion sought and obtained another protective order in the MyPillow litigation, specifically related to third-party discovery. This was in response to certain third-party subpoenas issued by defendants Michael J. Lindell and MyPillow Incorporated. After several rounds of briefing, the court entered the separate protective order governing third-party subpoenas in the MyPillow litigation. So all of these cases are kind of combined here for purposes of discovery. Lambert enters the case. Lambert first formally entered her appearance as Burns' counsel on March 12th of 2024. Burns' prior counsel, attorneys at McGlinchey Stafford here, withdrew the same day. Although Lambert did not appear in the case until March of 2024, it's undisputed she has been working with Burns and his team for some time prior to that date, unbeknownst to Dominion. McGlinchey and Lambert have both acknowledged that Lambert had access to confidential discovery material as an attorney for Patrick Byrne, who was assisting in this litigation. Prior to her formal entry of appearance in March of 2024, neither Lambert nor McGlinchey had, I'm not saying that name correctly, but that's fine, has provided an exact date for when Lambert began serving as Burns' attorney in this matter. That said, the record's clear that McGlinchey gave Lambert access to Dominion's litigation documents after she signed the undertaking pursuant to the protective order on December 12th of 2023. In signing the undertaking, Lambert guaranteed that she had read the protective order of June 16th of 2023 and would undertake to access the use discovery material, confidential material, and attorney's eyes only material only as the order permits. Lambert does not dispute that she executed the undertaking months before she disclosed the documents in March of 2024. Dominion did not have notice that Lambert had access to its discovery and had signed the undertaking until McGlinchey notified Dominion of the alleged breach in March 11th of 2024. And then we've got a direct quote. Miss Lambert Gentilla, and for the record, Your Honor, I did not provide that the undertaking to counsel. That must be provided by Mr. Burns' previous counsel, end quote. In fact, it appears that Dominion did not even know Lambert was involved in this case until after she had released countless Dominion discovery documents to a third party and inflicted damage Dominion could not undo. Lambert publicly disseminates confidential discovery material. So just as a moment, everyone, this whole situation of releasing information that's under a protective order, that's huge. That's a huge ethics violation in the legal world. Like that's a big no-no. Like we all know you're not supposed to do that. So this is pretty bad. On March 11th of 2024, McGlinchey notified Dominion that Lambert had publicly disclosed its discovery. McGlinchey told Dominion, quote, we had no advanced knowledge of this use. We only became aware of the public disclosure by virtue of the below tweet. Oh my gosh, everyone, Twitter again. Here we go. Election Integrity Force. Just in, Stephanie Lambert turns up the heat in Michigan's legal scheme with a fiery emergency motion for a stay. Read the explosive internal Dominion communications here. Whoa. Oh my gosh. McGlinchey notified Dominion that Lambert had disclosed Dominion's litigation documents in two ways. First, Lambert included the documents in a public filing as part of a Michigan criminal case in which she had been indicted on 4 felony counts related to the 2020 U.S. election. And then there's a citation to her case here, and we have footnote number 6. Lambert currently faces 2 sets of felony criminal charges in Michigan for allegedly attempting to interfere with voting equipment. On August 3rd of 2023, Lambert was indicted in Muskegon County, Michigan, on 4 felony charges related to alleged tampering with voting systems following the 2020 U.S. elections. Then on May 8th of 2024, Lambert and her client, Stephanie Scott, a clerk in Adams Township, Michigan, were indicted on felony charges related to allegedly mishandling voter data without authorization in search of fraud. Lambert's conduct described above occurred in the first of these criminal cases against her. Yikes. Oh, goodness. Lambert filed a pro se motion in that case, meaning no attorney was representing her, on March 8th of 2024 and attached Dominion's litigation documents as an exhibit. Second, Lambert shared the documents with Berry County, Michigan Sheriff Dar Leaf, an individual who has no role in this litigation, who went on to disseminate and discuss the documents in public. That same day, March 11th of 2024, Dominion Counsel responded to McGlinchey to request more information on the breach and to confirm that Lambert no longer had access to Dominion's litigation documents. McGlinchey withdrew from the case before responding. Ooh, yikes, everyone. That's a twist. Oh dear. When Lambert entered her appearance, Dominion Counsel emailed Lambert and McGlinchey to again request information about the scope of the breach. Lambert responded but refused to provide the requested information. Instead, she wrote, "Hi, Dominion Counsel. I had assumed that you as counsel were unaware of the criminal acts contained in discovery. These acts include but are not limited to perjury, fraud is services, wire fraud, and international interference in an election." Wow. If you were unaware of the criminal acts, I will need to address fraud on the court and potentially accessory after the fact with threats of violating a protective order that does not extend to criminal acts committed by your client. My client insisted the evidence of criminal acts be provided to law enforcement. I'm happy to address this with the court. Please let me know if you need anything else. Oh my gosh. What? That's out of control. This person's in some trouble. Sincerely, Stephanie. Yikes. Oh my gosh, everybody. That's a lot. Neither Lambert nor McGlinchey gave Dominion information about the scope of the alleged breach or provided any assurances that Lambert could no longer access Dominion's litigation documents. On March 14th of 2024, Dominion Counsel sent letters to managers of document databases that Byrne used for discovery with a copy to Lambert. Dominion notified those database managers of Lambert and Byrne's alleged breach and requested that the managers not allow Byrne and his legal team to access Dominion's litigation documents. Lambert wrote the database managers on March 15th of 2024 and insisted on maintaining access. Ooh, this is a lot, everybody. Lambert threatened that any entity that collaborates with Dominion to withhold discovery and to interfere with the disclosure of evidence in the case would be obstructing justice and would therefore be accessories after the fact to criminal acts. I don't think she's a prosecutor, right? I mean, my gosh, this is awful. Between December 12th and 2023, when Lambert signed the undertaking, and March 12th of 2024, Lambert made no effort to raise with Dominion or the court that she believed the documents were evidence of the most serious national security crimes that had ever been committed on U.S. soil, as she now claims. Oh my gosh. Nor did she notify Dominion or the court that she intended to turn over this evidence to law enforcement, referring to Leaf. Everybody can go to law enforcement and report crimes, and I have an oath and an obligation to do that. McGlinchey confirmed at the May 16, 2024 hearing that while serving as Byrne's prior counsel, it never sought to lift the protective order. Well, that's not what that oath means, actually. Oh dear, read your oath again. To de-designate any documents that were protected under the order or to seek any relief whatsoever from the protective order on behalf of Mr. Byrne. Instead, Lambert and Byrne unilaterally decided to disclose thousands, if not millions, of Dominion's litigation documents to third parties, and then promote the public dissemination of the document through those third parties. That's a lot. Dominion's motion in March 2024 hearing. On March 12th of 2024, Dominion notified the court of Lambert and Byrne's alleged breaches and sought the court's permission to raise this issue at a forthcoming discovery hearing on March 18th of 2024. On March 15th of 2024, Dominion filed this motion. Dominion only sought relief based on Lambert's actions, but reserved the right to seek additional sanctions based on Byrne's conduct. On March 18th of 2024, Lambert filed an opposition on behalf of Byrne shortly before the March hearing. Although Byrne reserved the right to supplement his response, he did not file a timely supplement or seek leave to file a supplement out of time. On March 22nd of 2024, Dominion filed its reply. Byrne then waited more than a month and ultimately sought leave to file a surreply on April 24th of 2024. If this stuff is so important, why are people missing deadlines? That's my first question. If this is such a big deal to people, like why are you waiting a month to file your surreply? Come on. Over Dominion's objection, the court granted Byrne's request for leave to file a surreply. Hours before the March hearing, Lambert posted the following on X. So here we go into the land of X, everybody. All right. Yikes. He's going to be in trouble. It's just not in this particular order. These people have, oh my gosh, I know it's a lot. All right, Stephanie Lambert. So this is her post on X. It's pretty significant, everyone. Let me just do a side note. When a judge is including a tweet in an order, I think that's pretty significant. I gave the evidence to law enforcement. The discovery file from Dominion contained evidence of numerous crimes. The Constitution does not permit secret Serbians to run our elections. What? Local clerks are to run our elections, and transparency is prevented by vendors. Dominion, what? That doesn't even make sense. When Dominion raised the prospect of sanctions, it noted that Lambert is familiar with the process since she was initially sanctioned for her involvement as local counsel in the Michigan Kraken lawsuit before an appellate court reversed. Lambert does not and cannot contest the requirements set forth in the protective order, which itself contemplates sanctions if breached. Rather, she apparently believes that she has the unilateral authority to decide whether or not she needs to comply. As a barred licensed attorney, Lambert is well aware the court orders are not optional unless she had any doubt the disciplinary referrals, bench warrant, and sanctions entered against her by various courts have surely apprised her of that fact. The motion said the only question for this court then is whether her violation warrants disqualification. It does. I know. What is Serbia? I don't know. What? We've got Venezuela. We've got Serbia. We've got this international situation. Yikes. At the March hearing, Lambert did not dispute that, one, she signed an undertaking verifying she would comply with the protective order, and two, gained access to Dominion's litigation documents, and three, disseminated those documents in a manner a Dominion alleged. So she's not denying everything that she did here. Oh my goodness. She also disclosed details about the scope of her alleged breach for the first time. She reported that she not only gave Leaf documents, but that she also gave him a username and password to the entire repository of Dominion's litigation documents. Oh my gosh, everybody. Oh, wow. Oh my gosh. Don't do that, people. Don't do that. Lambert did not represent that she asked Leaf to sign an undertaking pursuant to the protective order. So that's funny because the judge is like, well, and she didn't even ask him to sign. Like, she just gave him all this information and didn't even ask him to sign the form. Like, what? After Leaf gained access to Dominion's litigation documents, Leaf created an X, formerly Twitter, account and shared links so the public could download the documents. What? Leaf's post sharing the documents remain publicly available. And I have not pulled them up because that's wrong. Because that is bad behavior. Leaf also sent a letter to the House Judiciary Committee Chair Jim Jordan, asking him to investigate Dominion's alleged illegal acts. As of the date Dominion filed its reply on March 22nd of 2024, Leaf's post with this letter and the link to Tranche 1 had been viewed 473,000 times. According to Lambert, Byrne had reportedly also provided Dominion's litigation documents to a U.S. attorney and possibly others. Although Lambert claimed that she did not know the full extent of Byrne's actions, it became apparent that her accounting to the court of her own actions was incomplete as well. Wow. Of course, Jim Jordan's involved. I know. Oh my gosh. How did this happen, everybody? This is madness. Importantly, at no point did Lambert herself notify the court, Dominion Counsel, or McGlinchey that she intended to or had already disclosed Dominion's litigation documents. Status quo order. Coming up next here. Wow. At the March hearing, the court ordered temporary protective relief to prevent any further dissemination of Dominion's litigation documents and other discovery while the court considered this motion. Among other things, the court ordered Byrne and Lambert to immediately desist from sharing, distributing, providing access to, or discussing any discovery material received in this case and or the consolidated coordinated cases. The court ordered Lambert to ensure that individual who had access to Dominion's litigation documents or notes Lambert took on them not access or disseminate those materials, and that she sequester and secure the documents in any of her notes. The court ordered Lambert to immediately confer with her counsel in her Michigan criminal case regarding Dominion's litigation documents and undertake every reasonable effort to remove such documents from the public record and file them under seal instead. Wow. Not good at They're not. I mean, come on. But not all attorneys work in criminal law. I think that's the thing here, is that they're like, oh, I can just do whatever I want. I'm like, no. Further, the court ordered Lambert, Byrne, and McGlinchey to preserve all documents and communications relating to the issues raised by Dominion's motion, including but not limited to the release of any Dominion litigation documents, in this case, to any other entity or individual. Additionally, the court ordered that if Dominion's litigation documents existed in any form not already accounted for, including with any associate or affiliate of Lambert or Byrne, the relevant party's attorney, or party's former attorney must immediately notify the court. Finally, the court ordered that Byrne and Lambert file a verification that they have and will comply with each of their obligations in this order until further order of the court, no later than March 21st of 2024, 5 p.m. Eastern. Both of them missed the deadline. On March 22nd, 2024, after the deadline had passed, Byrne and Lambert sought to extend the deadline to file their verifications. Byrne and Lambert asked the court to extend this deadline to 5 p.m. on March 26th. The court granted Byrne and Lambert's request, but the deadline at 12 p.m. on March 26th, but set the deadline at 12 p.m. March 26th. Again, Byrne and Lambert missed not only the court-ordered deadline of 12 p.m., but also their requested deadline of 5 p.m. Lambert and Byrne did not file the verifications until 8:55 p.m. that day. Though belated, Lambert and Byrne submitted statements in which each verified that they have and will comply with the obligations set forth in the court's March 19, 2024 order until further order of the court. Conduct after the March hearing. Neither the court's March hearing nor the status quo order deterred Lambert or Byrne's continued misconduct. Lambert and Byrne continued to discuss and disseminate the documents. Man, these people, I tell you what, have a little respect for procedures, people. And in some cases, actively sponsored others' dissemination of the documents. Let me have footnote 7 here. At the May hearing, Dominion chronicled instances in which Lambert and Byrne continued to share and discuss the documents after the status quo order. Lambert and Byrne do not dispute the authenticity of their posts. They merely argue their conduct is permissible. For example, on March 19th, the day after the March hearing, Lambert made the following statement to ABC News. There was no leak of data. I provided evidence of criminal acts to law enforcement. The Dominion file contained evidence of perjury by John Poulos, Dominion CEO, honest service fraud, wire fraud, etc. I'm on my way back to Michigan, and I look forward to truth and transparency for everyone. And then here's footnote 8. Laura Romero and Luke Burr, pro-Trump lawyer, arrested on a warrant after court hearing in a separate case on Dominion leaks. And then there's the ABC citation here. Oh my gosh, worse than Hava. Well, oh my gosh, I think they're just bad in a different way. Everybody's got their own special criminal ways, I guess. Moreover, on March 22nd of 2024, Lambert appeared alongside Leaf on an interview that was posted on X. During the episode of Joe Altman's podcast with Conservative Daily News, Altman encouraged all listeners to download the Dominion documents Lambert had released to Leaf and send them to every county in the United States. As Dominion counsel recounted at the May hearing, on March 22nd, Miss Lambert sat for an interview on Joe Altman Live, and in that interview, Mr. Altman turns to her at 42:25, and he says, "We have evidence from Dar Leaf and way more that's not been released." And when he starts to discuss the evidence, he hesitates and he turns to Miss Lambert and says, quote, "Stephanie, I didn't get it from you. I got it from Twitter X," end quote. And Miss Lambert does nothing to stop him then from launching into a discussion of the documents. In fact, Miss Lambert follows up by telling Mr. Altman that he should have Dar on the show himself because he can go through the investigation. And when Mr. Altman asked Miss Lambert if Sheriff Dar Leaf is allowed to discuss his investigation and evidence, Lambert says Sheriff Dar Leaf can do whatever he wants. It's his investigation. You know, FYI, Sheriff Dar Leaf also took an oath to uphold the Constitution. I'm just saying, I'm just putting that out there. After the court gave her ample opportunity to explain her conduct, Lambert never contested that she made or shared any of the posts at issue, participated in any of the interviews, or otherwise engaged in the conduct that Dominion asserts violates the protective and status quo orders. Further, Lambert did not remove or make any meaningful attempt to file under seal the copies of Dominion's litigation documents that she had attached to a publicly available pro se filing in one of her Michigan criminal cases. Lambert claimed that she raised the issue with her counsel, Daniel Hartman, but that Hartman stated he could not ask the court in good faith that the documents contained some of the serious crimes in national history and are a matter of national security. Lambert did not inform the court that she failed to comply with this requirement. For his part, Byrne reposted and continued to emphasize posts on X about Dominion's litigation documents, despite also promising that he would comply with the status quo order. On March 18th of 2024, he shared Leaf's letter to Representative Jordan that referenced the documents. One of those constitutional sheriffs, good question. I don't know. I mean, come on, right? Oh my goodness, this is pretty awful, everybody. Pretty awful. Here we go. So we've got a post here, Patrick Byrne. There is no mincing PC sheriff. 3 more coming. Barrow County Sheriff's Office, Sheriff Dar Leaf, March 17th of 2024. The Honorable Jim Jordan. Dear Congressman Jordan, my office is investigating criminal acts related to elections in Berry County, the state of Michigan, and the United States. I'm in possession of evidence involving voting machines. Additionally, I have recently received a subpoena from Prosecutor DJ Hilson of Muskegon County for my file. DJ Hilson worked with the Michigan Attorney General to bury the Muskegon fraud investigation that was initially reported by the Muskegon local clerk. Not one person was charged related to the Muskegon fraud, despite confessions and physical evidence. Considering this, I'm going to provide portions of my file to Congress for immediate review and investigation. My office has come into possession of evidence that foreign nationals have accessed electronic voting machines in Michigan and other states. This evidence demonstrates that electronic voting machines and electronic election systems used for elections in Michigan and throughout the United States are not secure, and an immediate investigation is needed by Congress. So I guess is this the Serbians or is this the Venezuelan situation? I don't know. What the what? I don't know. Serbia, Venezuela, I'm not sure exactly who they're referring to here, but there you have that. On March 19th of 2024, Byrne reposted a video on X that was originally posted by Tina Peters, a former county clerk of Mesa County, Colorado, who is now a convicted person who was indicted for allowing unauthorized access to Dominion machines. Footnote number 9 here. Although the court does not grant Dominion leave to file a third supplement, the court acknowledges that Dominion alleges that in addition to representing Lambert in one of her criminal, gotta flip the page here for our footnote, cases, Hartman also represents Peters in her Colorado criminal case and has allegedly sought to introduce Dominion's litigation documents as evidence in that case. Oh wow, everybody, did anyone notice the Dominion documents in the Peters criminal case? I did not notice that. I did not notice that. I will have to take a look again at that. Wow. In that post, Peters used the name. Man, I tell you, this ex is just getting in all kinds of trouble here. And photo of Dominion employees in Belgrade, Serbia. Oh, there's the Serbia connection, everybody. All right, all right. Dominion asserts, and Lambert does not dispute, that this is a reference to Dominion's litigation documents. On March 20th of 2024, Byrne shared another post on X that named a Serbian Dominion employee and claimed connections between Dominion, vote counting software, and Serbia. Shortly after, Byrne responded to another X post about the source code protocol entered in this case. Byrne, and what is going to be really interesting is comparing that code to the Smartmatic source code. If only we could get it. Oh my goodness, making my eye twitch. Oh my gosh, everybody, this is just, oh my goodness. All right, May hearing. Here we go. Keep plugging along here. On May 16th of 2024, the court held a hearing to entertain more fulsome argument on Dominion's motion, which had not been fully briefed at the time of the March hearing. At the May hearing, Dominion chronicled Lambert and Byrne's actions and argued that Lambert's actions violated the protective and status quo orders and her ethical obligations as Byrne's counsel. This included a detailed presentation in which Dominion offered a timeline of Lambert and Byrne's misconduct using social media posts, interviews, and other statements. And we have footnote 10 here. The court ordered Dominion to file its presentation and supporting evidence on the docket by the end of the following day. Although Lambert disagreed about Dominion's characterization of these actions, she did not dispute either the underlying conduct or the authenticity of any of the documents Dominion cited in its presentation. The court reminded Byrne and Lambert that the status quo order expressly prohibits them from sharing, distributing, providing access to, or discussing any discovery material received from Dominion in this case. The court made clear that the discovery material referenced in the status quo order is the same broad definition of discovery material in the protective order. Here, yes, oh my gosh. The court confirmed with both Byrne and Lambert on the record that they understood these orders and would comply with them, especially the provisions prohibiting them from sharing, disseminating, or discussing discovery material. Both Lambert and Byrne agreed. The court also gave both of them multiple opportunities to ask questions about the scope of the order. Lambert had no questions. The only question from Byrne was what he should file if he requested by Congress or the DOJ or law enforcement to cooperate with an investigation. Wait, hold on. What did he do? Oh my gosh. Backing it up, everybody. The only question from Byrne was what he should do if he is requested by Congress or the DOJ or law enforcement to cooperate with an investigation. What? The court reiterated that Byrne and Lambert must come to this court first. The court warned the parties that some of the actions purportedly taken in the name of law enforcement aren't entirely supported, and reiterated that they need to follow the strict guidelines of Judge Nichols's order to come to the court if there are any such requests. Lambert thanked the court, and neither Lambert nor Byrne had any additional questions or apparent reservations. Conduct after the May hearing. Yikes. Despite assuring the court that they understood and would comply with all of its orders, Lambert and Byrne continued to disregard them. For example, the morning after the May hearing, Byrne shared a post on social media that included screenshots and discussions of Dominion litigation documents. My gosh, everyone. Footnote number 11. In the post, the user claimed Dominion's authenticated all of the data released by Sheriff Leaf in the May hearing and included screenshots of Dominion's litigation documents. Oh my gosh. On May 21st of 2024, Dominion notified the court of Byrne's actions. On May 28th of 2024, Lambert, I feel like these people really are just, this is not good lawyering, submitted a response on Byrne's behalf. Lambert did not dispute that Byrne shared the post containing Dominion's litigation documents, instead arguing Dr. Byrne's posts were nothing more than the reposting of information that had already been posted and did not constitute a violation of this court's order, precisely because the orders did not disseminate further information beyond that which the court has already taken account of in its previous order. Dr. Byrne did not post any new information, and the repost constituted information that was already in the public sphere. Thus, not only has Mr. Byrne not violated the court's direct order, but he has also not disseminated or published any new information in contravention thereof. Oh my gosh. Okay, footnote 12. Yes, exactly right. Footnote 12, Lambert claims that Dominion previously sent only to the court its notice of filing a letter raising this alleged violation. This is incorrect. As the electronic filing receipt from Dominion's filing shows, Lambert received notice of the letter, a receipt for number 104. The clerk rejected Dominion's initial filing for being in the wrong format, a letter instead of a motion, and instructed it to refile, which it did the following day. Wow. Wow, everybody. I feel like our sanctions for attorneys behaving badly is not enough. All right? I've said it. I stand by that. I think it needs to be more than whatever it is, which is not enough. In other words, because the documents were already in the public dominion, due to Lambert's own unilateral actions, Lambert argued that they were no longer subject to the strictures of the protective order. In making the argument, Lambert relied on an exception to the protective order that did not exist. Nothing in the court's status quo or protective order shields a party from sanctions for reposting or sharing documents already made public due to that party's own violation of those orders. Moreover, Lambert did not come to the court to raise this question, despite promising to do so at the May hearing. Instead, she continued to assert a right to decide unilaterally when she and Byrne could share Dominion's litigation documents, notwithstanding repeated court orders to the contrary. Lambert did not stop there. In addition to attempting to excuse Byrne's violations of court orders after the May hearing, Lambert continues to attempt to disclose Dominion's litigation documents and other discovery herself. These events are described in Dominion's July 5th, 2024 motion to enforce the protective order and status quo orders. And its July 23rd, 2024 supplement to its underlying motion for protective relief and to disqualify counsel and motion to enforce. Notably, Byrne and Lambert do not dispute the facts in those briefs. So here is footnote 13. In a one-page response to the filing, Lambert merely claimed that Dominion fails to request any new relief in its motion to enforce. She does not rebut any of the factual grounds for Dominion's motion. Even though she gave no justification for her request, the court permitted Lambert to file a surreply. By July 26th of 2024, Lambert belatedly filed the surreply and vaguely asserted that she would comply with the court's orders, but refused to provide confirmation based on privilege. The court permitted Lambert to file a response to Dominion's supplement by July 26th of 2024, but Lambert did not file any response. Oh, sorry everybody, I've got a puzzle piece here. Woo! Did we do it? We got it. Verification done. Okay, the court permitted Lambert to file a response to Dominion supplement by July 26, but Lambert did not file any response, seek any extension, or otherwise indicate she would respond. Wow. Wow, I agree. This is quite wild. This is really bad. Yikes. First, Lambert attempted or threatened to disclose Dominion's litigation documents in response to a subpoena in Colorado's criminal case against Peters. On July 1st of 2024, Lambert notified Dominion that Peters' attorney subpoenaed Lambert to testify and produce documents in the Peters criminal case. Paragraph 22 of the protective order sets forth procedures on how a party must handle such request. Dominion responded and asked Lambert to confirm that she and her client would abide by the protective and status quo orders and not produce documents or other discovery materials to anyone. Lambert disagreed with Dominion's reading of the protective order and asserted that it was up to Dominion to file objections to the subpoena within 48 hours if it wanted to halt her compliance. What? Dominion again pointed Lambert to the plain language of the protective order and asked her to confirm that she would comply with the requirement, that she objected to the subpoena. Lambert repeatedly refused to confirm that she had and would comply with her obligations to object. During these email exchanges, Lambert also argued that the materials were improperly labeled confidential or eyes only, though she had not previously raised the argument in accordance with the process set forth in the protective order. Yeah, this is really bad. She's the Supreme Court yeah, exactly. Like, there's actually rules we have to follow here. But I guess the only rules are her rules that she wishes to follow and how her rules are written. Second, Lambert attempted to disclose deposition testimony from Dominion CEO John Poulos in response to a request from a Michigan State Representative, James DeSana. On July 12th of 2024, Lambert notified Dominion that she received a request from DeSana for Poulos' deposition testimony. Dominion objected to Lambert sharing the testimony on the same grounds as the first subpoena, as depositions clearly fall within the definition of protected discovery materials in the protective order. So now we just have state representatives asking for private information in a civil lawsuit. Yikes. In response, Lambert asserted that this situation was different as it was not a person requesting the transcript in its individual capacity. This is a request by the government, the Michigan legislature. She also asked Dominion to specify which portion of the deposition it objected to her sharing with DeSana, evidently still contesting that the protective and status quo orders apply to all discovery materials, despite the court ordering otherwise. As Dominion lays out in its supplement, this request did not appear to be from the Michigan legislature through any formal process or request, but instead is an email from an individual legislator. And we've got footnote 14 here. Dominion points out that the Michigan Attorney General already dismissed a request by DeSana and others for the Attorney General to bring criminal complaint against Dominion 3 months before. So that's interesting. So we have the AG in conflict with this individual legislator. Dominion also pointed out that even if the request were from a member of government, it would not vitiate the protective and status quo orders. As the court expressly warned at the May hearing, because Lambert again would not confirm that she would comply with the protective order and object to the subpoena, Dominion sought the court's assistance on July 12th of 2024. The court entered a minute order reiterating what it had previously ordered, that no discovery materials shall be shared to unauthorized individuals without expressly obtaining the court's permission. I'm just wondering at what point, I feel like the court really gave her a lot of chances here. Like they really gave her a lot of opportunities to do the right thing here, like a lot. The court expressly prohibited Lambert from sharing Poulos' deposition with DeSana without obtaining court approval. Lambert has not filed any request to lift the protective and status quo orders for this purpose. Footnote 15. Instead, on July 19th of 2024, Lambert filed a motion for leave to file an emergency motion to lift the protective order for the specific purpose of producing documents in the Peters criminal case, not attaching the proposed motion to her filings. Interesting. Finally, it recently came to light that John Case, another attorney who represents Peters in the Peters criminal case, is also assisting Lambert with Byrne's defense in this case. Lambert never notified Dominion or the court that Case is at all involved in this litigation. Dominion discovered this fact for the first time because Case filed a declaration in the Peters criminal case on July 10th of 2024, stating, "I'm assisting Stephanie Lambert in her defense of Patrick Byrne. I signed Exhibit A to protective order, an undertaking which I agreed to access and use discovery material, confidential material, and attorney's eyes only material only as the protective order permits. I reviewed emails produced by Dominion. The emails appear to be mislabeled confidential because their contents do not meet the definition of confidential material in paragraph 2 of the protective order, June 16th of 2023. Lambert refused Dominion's request for information about when Case joined Byrne's defense and what discovery he accessed because of privileged work product. She even objected to providing the undertaking that Case supposedly signed to gain access to Dominion's litigation documents. Nor has Lambert provided any details to the court about Case's involvement, despite the court directly requiring Lambert to give a full accounting of who had access to Dominion's litigation documents. Case's involvement in this litigation is not only striking because Lambert hid this information from the court, Case has also attempted to use processes from other judicial proceedings, such as the Peters criminal case, to access and release Dominion's discovery materials from this litigation. This includes the subpoena to Lambert that is subject to of Dominion's motion to enforce. In summary, while Case is ostensibly working with Lambert to advise Byrne on this case and signed an undertaking to comply with the protective order, he's also seeking to use Dominion's litigation documents and other discovery in contravention of this court's order. Lambert is at least justifying, if not also facilitating, his efforts. Could Dominion now sue Lambert and Byrne? Yes, I think so. I think Dominion could definitely ask for sanctions, and they reserved that right. With that, everybody, I will go ahead and stop my reading at this point. We have made it through 24 pages out of our 62, so I will go ahead and pause for tonight's reading. I feel the heat coming off of my camera here, so we will pause there. I'll pick up the rest of this tomorrow. But what are our thoughts, everybody? This is just really, really out of control. Thank you. Oh, you're welcome. You're welcome. This is really, oh my gosh. This is really awful, really awful. And I've not read or seen if there have been any ethical violations filed here, but I would imagine there would be, or there should be. There's more. Oh, yes. We're just stating facts right now. We still have the part where the judge puts the sanctions into place. So we're only in the first, I've only read part 1. I want to recap. Oh, no problem. They've lost their ever-loving mind. I think that's a great recap. It's some Clarence Thomas kind of stuff. Yes. So, all right. So the Dominion, poor Dominion. I feel bad for them. I really do. So they're suing this Byrne fellow for defamation. And he had one set of attorneys, and then this Lambert attorney came in, and all of the information during the discovery period in a civil case is, you got to be careful with it in order for everyone to have a fair, appropriate, situation going on in court. There's just procedural rules that are just basic procedural rules. But Lambert came in and took those discovery documents, gave them to another person, and it got disseminated widely through the Twitter, and nobody stopped it. And she was repeatedly told to stop it. Mr. Byrne was told to stop it. They didn't. And so now all of this private discovery information has been put out there into the public. Now, let me just clarify. I'm not trying to say everything should be, hush hush and this information shouldn't be known by the public. But what I'm saying is there's a process you go through. You have to follow the rules. If you want this information made public, she should have followed the rules and requested the process of making it public. And I'm not trying to, again, say, hide everything, but I am saying you have to follow the rules. If you want to share information, follow the rules. If all of this information would come out later on anyway, no matter what, during trial, it's going to come out. As we all saw in the trials that we watched, all this discovery information comes out anyway. So it's not like there's some big, huge secrets that need to be, hidden here. But the way that they did this is violating rights of dominion. I mean, they have, we all have a right to a fair trial, right? And I know this is a civil case, so our rights are diminished. But on the other hand, there are rules you have to follow here. And again, all of this private documentation is going to negatively affect the possibility of them having a fair trial in this situation. And that's just really, that's really awful. And one of the worst things you can do as an attorney is to sabotage through illegal, wrongful means another case just because, I saw something that I think is illegal. Like, that's not a thing. That's not a thing. Just because you think a crime has occurred does not mean that all the rules don't work anymore. One of the things that Mr. Trump said on January 6th was, once there's fraud, no other rules apply. Everything else doesn't apply now that there's been fraud. That is not true. That is just not true. All rules apply all the time, unless the judge says your rule doesn't apply anymore to your face. All right? So just because she thinks there may be some criminal stuff going on doesn't mean she doesn't still have to follow the rules. That's what the law is about. The law isn't always about, it's either A or B. The law is also about how you get from A to B and how you present it. That's also part of the legal system. He's giving them awards. Well, yeah, I don't. To each their own, I guess. People need those, I guess. Seems like they believe the rules don't apply to them. Well, it does. It does. And I think one of the biggest issues here is that a lot of these attorneys and these people involved here think that their own justifications are above the actual rules. So like Sidney Powell, her belief in things being wrong and illegal, her belief in that is more important than all of the other rules in the United States. None of the other criminal, procedural, civil laws apply to her because she believes she is doing something so righteous that it is better than any of the other rules. Like, that's just not how it works here. We do not have a single person who gets to go forward and make all of the rules. We just don't. I mean, at most we have 9 people, but just Sidney Powell, like, who do these people think they are, that they're so special that their beliefs are more important than everybody else's? And it's just such a huge power play and such an abuse of power and such an overwhelming sense of self-importance. It's just, sometimes it's almost too much to take into account here. It's really unfortunate. It's really unfortunate. And I hate to see it. And it continues to happen time and time again, where like Giuliani's like, I'm the greatest person on the planet. So, whatever I say is how it is. It doesn't matter who's getting hurt. And, Sidney Powell's the same. And Mark Meadows is like, well, I was doing it because it was my job. So, whatever. It's like, come on, people. There's rules. We have rules to follow. On the Yes, I still have my indictment scores going, everyone. We still have those. We still have those. For sure. All of these cases are ongoing. And again, the legal system is slow. It's very slow, but it continues on. It goes on and on and on and on. And eventually everybody, gets called out in time. But I'm just thinking to myself, like, wow, how important does this Stephanie Lambert person think that she is, that her beliefs are more important than the entire legal system, Like, you think you're that special. Like, what makes you that special? Like, did your parents tell you you're super special? Like, what happened to make you think that you're so great that you get to make the decision for the entire United States? It just is really frustrating. It's hard to watch because we have egos as attorneys. We have to have egos in order to do our jobs. But an ego at this level, like, wow. Who's Patrick Byrne? Exactly. Who is Patrick Byrne? Who's Mr. Byrne to think he can do this? Oh my gosh, Shadow, thank you so much. Oh my gosh. Oh, look at the ducks. Oh, thank you so much, everybody. Thank you so much. Yeah, I don't even know who this fella is. He's just some, fella that was out there making comments about, Hugo Chavez. Like, what? The cup of delusion. I know. Well, we do have an ego, but with there, you have to have some ego. And law enforcement, you gotta have some ego. I get it. But also, like, you're not that special, people. You're really not that special. Like, and I hope Lambert, when she's sitting in prison, she can acknowledge for a minute when she's looking at her, situation, maybe she can acknowledge she's just not that special. Maybe for a moment. That's my thought. Or anyone that decides to go down this road and make a decision for, the entire country because you think you're that special. Like, it bothers me a little bit. These cases are a lot. They get to be so much where, and I would say this about anyone in a position of power. When we had the gold bars case, the Menendez case, like, he just thought he was so special that he was going to run a deal, that it was somehow going to benefit, not just him, but, the country somehow. Like, that to me is just so frustrating when people feel like they just know what's best for everybody. Like, that's just not how this works. You are not a king. This Miss Lambert is not the queen to make this unilateral decision, which is what the judge is saying here. She doesn't just get to decide what's legal and what's not legal. Even if she's got training, you still, like, don't get to make those decisions, right? Not losing custody of her cat while she's in prison. Oh, no. Oh, my goodness. Both sides hold them accountable. Exactly. Everybody needs to just, take a cup of and just sit down for a minute and recognize you're just not that special. And maybe that's not very nice of me, but maybe I'm putting my nice ticket to the side for a moment, everybody, because these people are just not that special. No one's that special. It takes a team. We're a team here. The United States, we've got teams of people for reasons. Oh, you call Taylor Swift? Oh, no, protect the cat at all costs. Oh, it's we the people. Exactly. Not me, Miss Lambert. I'm gonna just be like, oh, that looks illegal, so it must be. Like, that's not your call, ma'am. You don't make that call. Where's the jury? There's no jury indictment here. What's going on? That's not your call. Taylor, oh, she is the queen. Taylor's the queen, everybody. Let's take a moment and acknowledge that. Miss Taylor Swift, that's a different story. She's in her own category. She's in her own category, everybody. So, yes. So these cases are very frustrating to go through when somebody goes to law school, gets a little bit of legal experience, and then starts, like, throwing around their own beliefs and their own, like, well, this must be illegal because I, learned that something was illegal. Like, hold on here. Come on. We don't make those kinds of unilateral decisions here. We just don't. And it's not appropriate. Miss Lambert is going to be, she's been charged and indicted in multiple cases. Miss Tina Peters was charged as well. Like, you don't get to make those decisions. That's not your decision to make. That's not your call. And by making that call, you're getting yourself into some trouble. So Follow the rules, people. That's it. I'm a big fan. Follow the rules. Follow the rules. And convicted. Yes, she was convicted. So Tita Peters was convicted. Yep. So follow the rules, everybody. Follow the rules. Well, they can go to prison what's most likely going to happen. You never know. We don't have a conviction here. We only have indictments, which is a finding of probable cause to go forward. We do not have findings of guilt beyond a reasonable doubt, but we definitely have in that. Give them the benefit of the doubt. Well, you just never know. I mean, come on. I feel like we cannot ever guarantee one way or another. It's up to the jury to decide. That's the system. That's the process. I'm also not special enough to decide if someone should go to jail or not. I'm not that special, How they keep getting on new cases if they're so awful. Great question. And I think it's because, we don't have enough people monitoring. I think the more lights that we can shine on people behaving badly, especially attorneys behaving terribly badly, the better. I think because people can watch out for it. It's that situation where everyone just kind of keeps doing what they're doing in their daily grind until you look and say, oh my gosh, how did that happen? Because no one was paying attention. But now everybody's drawing so much attention to themselves that, they're basically, confessing just out in the public on their social medias. You're super special. Oh, you're so sweet. Well, it's not my... I'm not as special as a jury. All right, I'll put that there. Oh, look at that. Oh, you guys. Oh, that's so sweet. Oh, thank you so much. Thank you so much. That was so adorable. So... Yes, I'm really not. I'm not. Oh, you're embarrassing me. I'm blushing, everybody. All right. So, so that's kind of the recap here. We have an attorney who's trying to, I guess, take over the world. And she's getting called out and shoved off this case because she's way out of line. What's my favorite nail brand? Oh, good question. Good question. I don't really have a favorite at this point. I'm looking around. I really don't. I don't even pay attention. Like I can't even think of the nail brand that I use tonight. I have I have several boxes now. I used to have everything in a cart, but now I've just got boxes. I have my box of Halloween nails I'm very excited about. I have my box of nails that last longer, so it's just a lot of fun. These are so cute. Oh, thank you so much. Thank you very much. These will probably be on for a couple of days, so it just depends. I do have a really fun time. I just enjoy the nails. I enjoy it. It's a lot of fun. Pinky in the brain. Exactly, Willie B. That's what I'm saying. Like we're gonna take over the world. Like, come on, knock it off. Knock it off. Why do you want to do that anyway? I mean, so what? You can buy a better car? I mean, like, what's the purpose? Like, what's the point? Like, power and prestige? Because forget it. Those are super cute. Oh, thanks. These are kind of the last of my summer nails here. So, having the last of those. I've got some vampy nails coming up, everybody. When the fall hits, we will definitely have some vamp time for everyone. So, oh my gosh. Well, with that, everyone, I will go ahead and sign off for tonight. It's, as always, wonderful to be able to hang out with everybody. I'm so glad I was able to come and do my sub chat Sunday. I will be planning to come back tomorrow to finish the second half of this opinion, all right? We really need, I think, we need that accountability. We need that closure. Or at least I need it, everyone. I need closure. So I'll be back again tomorrow. We'll do 7 o'clock Central. That time's going to be working best for me at the moment. So Monday, tomorrow, 7 o'clock Central, I'll have... I'll go ahead and read through and then turn comments on. I'll kind of flip it that way so that the moderators don't get overwhelmed. So I will read through the second half of this opinion tomorrow. We'll do a Q&A at the end and kind of put this to rest as we watch how these cases unfold. So thank you all for coming and hanging out with me tonight. It's been so much fun. I always appreciate my subscribers. Thank you so much for your amazing toner, fun, and paper. Oh my gosh, so grateful. I will be back again tomorrow night as long as everything goes as planned, of course. So I will see you all then, and I wish you all the best. Have a great Monday, everyone, and we'll talk again very soon. So have a good night. Bye, everybody. Take care. Bye, Kristen.